Smartphones have turned millions of us into instant documentarians. From viral street videos to so-called First Amendment audits, recording public officials has become a form of citizen oversight and sometimes entertainment. But does the First Amendment really give you an unlimited right to record? The answer is more complex than many think. Today, we'll unpack the real law, including forum doctrine, expressive conduct, time, place, and manner rules, and why not illegal doesn't mean constitutionally protected. The first key concept is forum doctrine, the framework courts use to determine how much free speech protection you have on government property. There are four main categories. 1. Traditional public forums, like streets, sidewalks, and parks. These have the strongest protections. Restrictions must be content neutral, narrowly tailored, and leave open other ways to communicate. 2. Designated public forums. These are opened by the government for expression, such as a city auditorium for speeches. They get similar protections while open. 3. Limited public forums. These are open only for certain topics or groups, like a school board meeting agenda. 4. Non-public forums such as military bases, secure office areas, and courthouse interiors, where broad, reasonable, and viewpoint-neutral restrictions are allowed. This framework comes from Perry Education Association v. Perry Local Educators Association, 460 U.S. 37, decided in 1983. If you're filming police on a public sidewalk, you're in a traditional public forum with strong First Amendment protections. But if you're filming customers at a DMV, you're in a non-public forum. The government can lawfully set a no recording rule and enforce it through trespass laws. The principle is reinforced in Cornelius v. NAACP Legal Defense and Educational Fund, 473 U.S. 788, 1985. The First Amendment protects more than spoken words, it covers expressive conduct. To qualify, two things must be true. 1. You intend to convey a message. 2. It's likely that message will be understood. This test comes from Texas v. Johnson, 491 U.S. 397, 1989. Recording police misconduct to share with the public meets this test. Filming random strangers in a government lobby without purpose? Probably not. One of the most dangerous myths is, if it's not illegal, it's my constitutional right. Not illegal means there's no statute against it. A protected right means the government must meet a high legal standard to stop you. For example, wearing a hat indoors isn't illegal, but in a courtroom, a judge can order you to remove it, and you must comply. The same logic applies to cameras in non-public forums. Auditors often claim recording is protected because they're the press. But the press clause doesn't grant special privileges. It guarantees that everyone, press or not, has the same rights to gather and share information. Courts ground citizens' right to record in the speech clause, not a separate press privilege. Courthouses often prohibit filming without judicial approval. Administrative offices can limit cameras to protect privacy and maintain order. Legislative chambers may allow cameras, but under strict decorum rules. These restrictions are legal if they are content neutral, reasonable, and apply equally to everyone. The Supreme Court confirmed this principle in United States v. Cokinda, 497 U.S. 720, 1990. Telling you to turn off a camera isn't the same as discrimination. Viewpoint discrimination, like banning speech based on opinion, is almost always unconstitutional. A no cameras policy that applies to everyone, regardless of viewpoint, is content neutral and lawful in a non-public forum. Before recording, ask yourself, what forum am I in? Is my recording expressive? Are there posted rules? Are they content neutral? And do I have other ways to express my message? This quick checklist can help you stay within the law. Let's debunk some common auditor claims. Claim, I can film anywhere as press. Reality, forum rules still apply. Claim, signs don't matter. Reality, in a non-public forum, posted rules carry legal weight. Claim, you can't trespass me from public property. Reality, you can if you violate lawful, content, neutral conditions of entry. Here are key supporting cases. Glick v. Cuniff, 655 F. 378. First Circuit 2011. Recognize the right to record public officials in public spaces. Smith v. City of Cumming, 212 F. 3-1332, 11th Circuit 2000. Right to record, subject to reasonable restrictions. Perry Education Association v. Perry Local Educators Association, 460 U.S. 37, 1983 Established Forum Doctrine. Cornelius v. NAACP, Legal Defense and Educational Fund, 473 U.S. 788, 1985 Non-Public Forum Rules must be reasonable and viewpoint neutral. United States v. Kokinda, 497 U.S. 720, 1990 Upheld restrictions in non-public forums. Texas v. Johnson, 491 U.S. 397, 1989 Test for expressive conduct. Misused cases. Fordyce v. City of Seattle, 55 F. 3-436, 9th Circuit, 1995. Often overstated, does not override forum rules. Chambers v. Baltimore and Ohio Railroad Company, 207 U.S. 142, 1907. Not a blanket public access case. The First Amendment is powerful, but not limitless. Understanding its boundaries doesn't weaken your rights, it strengthens your ability to use them effectively. Don't just film the government. Understand the rules that make your filming lawful and persuasive.